State of Ohio versus Kyle J. Smallwood, 22 CR, Kyle Joshua Smallwood, I should say, 22 CR 78 and 22 CR 110. Present on behalf of the state is Assistant Prosecutor King. Present on behalf of the defendant is Attorney Dennis Kirk. You are Kyle Joshua Smallwood?
Correct.
All right. This matter is set for trial on February the 9th. And I think both of them are set at the same time. Has there been a motion filed for a joint trial?
I believe there has been, and it's been granted. Yes, there has been.
I couldn't recall.
The motion, at least I found the motion, it was filed on November 4th.
When was it? November
Motion.
4th? All right. Now, I did receive a communication dated the 16th from Mr. Smallwood. I didn't get it till late yesterday afternoon. 16th was a holiday, so I think it was brought up from the sheriff's office sometime after lunch yesterday, in which Mr. Smallwood has indicated that he wants to be his own attorney. Now, are you aware of that, Mr. Kirk?
I am aware of the request. Yeah, I've not seen the actual document, but on Monday I met with my client and he informed me of the same.
All right. So, Mr. Smallwood, would you like to address that incredibly bad idea?
I would like to address that, yes. I'm not saying that I want to completely go per se, but have him as co-counsel versus not have any counsel at all.
Well, the options are this under the law. You have an attorney to represent you, which is the smartest thing to do, or you can represent yourself. You can't be co-counsel. If you decide to represent yourself, the court does appoint a standby counsel, but that person doesn't sit at the table. They sit back away from you, and you have the right to consult with that person, but they don't participate. So you don't get to have your cake and eat it too, so to speak. And so that means that you would be in charge of your own defense, and you would be subject to the same rules that an attorney is. You don't get any breaks because you're a lay person. Now, you indicated that you're unhappy because you haven't got your discovery. Have you provided his discovery, Mr. Kirk?
Yes, I did provide the discovery.
Okay.
I have not received discovery.
You know how long ago?
I thought I did.
I've received no such thing at all.
So I could be wrong.
Did you ask him for that before you sent me a letter?
I did.
Okay.
I could be wrong. I thought I took it out early on in the case.
Okay.
I know there's been some trips to Twin Valley and things, but I can provide it again.
Yeah, okay. I mean, it's not that extensive. From what I read, I mean, this case is pretty straightforward. I think that the witnesses are clear from at least from what I read in the reports in terms of the evaluation and the discovery. So I don't know. So, he can give you that, but that, he's your attorney, so, I mean, he's the one that's representing you, at least right now. So what do you think you're going to do with that?
With the discovery?
Yeah.
I have no statements pertaining to the alleged victims. I have nothing to go on. Basically, other than knowing what I'm charged with is not factual.
I will say I have gone over the facts of the case and summarized the case.
Well, he can provide that to you, so the fact that you don't have it, I mean, you're not your own attorney at this point. He's your attorney. He has it. He thought he gave it to you. So here's it. Would have been the good thing. The best thing to do would be to communicate with him about that. But he'll get that to you, obviously.
I've made futile attempts at that. I've called his office and they hang up. My mom's called his office.
The only calls we get are collect phone calls from the jail.
They don't take collect phone calls from the jail.
Take collect calls.
Nobody does it, I'm aware of.
I was under the understanding all the attorneys on the roster for the courts were free calls from the jail.
Well, I have no clue where that came from.
It's been that way for a long time.
News to me. Yeah. News to me.
I've summarized the case for him. I went over it in great detail, but I'm more than happy to
Yeah.
print everything off again and make sure he has it in his possession.
Okay, well, that's, you go ahead and do that, okay. So, the question, Mr. Smallwood, is, we need to address this now, is, whether you truly want to be your own attorney and represent yourself, and have Mr. Kirk as standby, meaning he would be available to give you advice during breaks and stuff. It's not going to be like where he's sitting there and you ask him every question or everything. He can't, because that means that, he's representing you. So, that's not the way it works.
From a procedural aspect, I can adequately represent myself
Well, okay. Why do you think you can do that?
because I've been in trouble before.
Oh, okay. So that makes you an expert in
No, it doesn't
representing
make me an
people?
expert. My intellectual capacity is up to par.
Is what?
It's up to par.
Okay, because originally you were found not to be competent to stand trial.
Correct, and the reason I was found incompetent is because I made 3 specific statements. 1, that my attorney arrested me. 2, that the prosecuting attorney's father is a human trafficker. And 3, the last judge that sat on your bench had a 54-count indictment. And they told me I was crazy, that none of that happened. And in actuality, it all happened.
Well, I know the last one did. I don't know if it was 54 counts. It was a lot.
And Mr. Kirk was
I know your attorney didn't arrest you.
He has.
Well, attorneys don't have. Oh, okay. You mean back when he was a deputy? I got
Correct.
I recall him from my career in law enforcement. I do not recall personally arresting him. I mean, I don't know, but
Okay.
I've never used that in any way
I
against
got you.
him.
All right. All right. Well, when he arrested you, he wasn't his attorney. So technically, that's not a correct statement. The correct statement would be, my attorney arrested me when he was a deputy, not when he was an attorney. So
Correct. So
okay. But anyway, so how far did you go in school?
12. I'm a commercial electrician, licensed.
You have a high school diploma.
Correct.
Have you done any studying since then?
What?
Post high school, after high school?
I'm a licensed commercial electrician.
Okay. Teach you any law courses in that?
No.
Okay.
Civil classes are
Yeah.
remotely the same.
Well, here's the situation. You're charged with 2 counts of trespass and habitation when persons present or like to be present, which is felony of the 4th degree. And if convicted, each of those carry a possible sentence of at least 6 months minimum, up to 18 months. And then in the 110 case, you're charged with menacing by stalking in count 2, and that's a 4th degree felony as well, and carries the same penalty. So you're talking about a possible prison term of somewhere between 6 months as a minimum and 18 months as a maximum on each count. That would be a range and possible of 6 months to 54 months in prison. And let's see, is there a PRC in this case?
Yes, there is, Your Honor.
How much is that?
It's filed, on May 9th of 2022, there were 1,008 days remaining.
And 22?
Correct.
All right,
May
so
9th of 22.
1,000, so we're somewhere around 700 approximately days, okay? So that means it could be 54 months plus whatever time's left on the post-release control, because it's more than 1 year, and under the law, if you're convicted of a new felony, then you can get a year or whatever time's left, whichever is more.
And that's the greater of the 2, either the maximum amount of sanction time and or the maximum amount of probation time. Because my sanction time is 6 months,
No, the time on post-release control.
the probationary period.
It's not probation, it's post-release control.
Post-release control period.
Correct. And so that means that if you had 1,000 and some days back in May of last year, we're now about, that's been about 8 months, so 250 days or so would be off of that. You'd be looking in excess of 700 days more if you're convicted. As far as lesser offenses, I suppose if there could potentially be a lesser offense of criminal trespass if there wasn't anybody present and you trespassed, if that's what the evidence showed, but there would have to be a reasonable possibility of that, so I don't know, wouldn't know until the evidence was presented whether or not that's a possibility. And in the menacing by stalking, I think that's I don't know that there would be any
I'm just going to tell you right now, this is a mess.
Okay.
It's an inadequate mess
well,
from law enforcement perspective.
an inadequate mess.
It is a mess. It's a
And what would an adequate mess be?
It's a word of a war of words. Basically,
Well,
they're been
that's the same
added-
case of every case is that way.
I understand.
You know, that's what the whole point is
I understand.
each of them.
It's a
And don't interrupt me. But basically, the evidence is presented, and then, you know, the jury will make a decision as to what evidence they believe and what evidence they don't believe. But getting back to the point, I'm not here to listen to you argue about the case,
Right.
because that's what the trial would be for. But I'm just trying to explain to you what you're looking at. So you're looking at a potential of 54 months, plus another 750 days. That's 750 days is over 2 years. 54 months is 4.5 years. So you're looking at a potential maximum sentence of 6.5 years if you're convicted of everything, and sentenced to prison. And my policy is a person convicted of a felony while they're under post-release control, they get the post-release control, and that's consecutive by law. Now, there's also fines available of up to $5,000 on the two, or I'm sorry, $5,000 on the 4th degree, which is the stalking, and $2,500 on the, no, actually, they're all 4, so it's $5,000 each. So that's a possible $15,000 fine. Now, you understand those penalties?
I do, sir.
All right. Now, regarding possible defenses to this, this allegations, you know, there's been an evaluation on your mental state at the time, and there is no basis for an insanity plea, and so you cannot use any evidence of alleged mental state at the time as far as not being able to commit the offense because of that, so you would not be able to use that. I don't know what other defenses are, you know, other